The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, the 3rd of February, 2016, are currently trading with gold at $1,138.10 an ounce, silver $14.63 an ounce, Texas crude $29.88 a barrel, and Bitcoin is currently sitting at about 370 U.S. currency. Today in history, the year 1966, the Luna 9 Russian spacecraft became the first unmanned probe to achieve a soft landing on the moon, or any other planetary body for that matter. Also known as the YE-6, number 13, it was the first probe to transmit photographic data to Earth from the lunar surface. In recent news, Sandra Merritt, one of the two indicted with tampering with governmental documents in order to create fake driver's license in a plot with anti-abortion activists to obtain the undercover video footage exposing Planned Parenthood for selling human body parts, turned herself into Texas authorities today. She posted her $2,000 bond and was later released. However, the news conference that she was scheduled to hold afterwards was canceled. David Daleiden, the main activist behind the videos, plans to turn himself over to authorities tomorrow, as attorneys have stated. He does ironically face an additional misdemeanor charge related to the purchase of human tissue. Ironic because, if you recall, a grand jury in Houston, Texas, that had been tasked with looking into the wrongdoing by Planned Parenthood announced that it was indicting Daleiden and Merritt instead. The results for the Iowa caucus are as follows. For the Republican Party, Ted Cruz, 8 delegates, or 27.7%. Donald Trump, 7 delegates, or 24.3%. Mark Rubio, 7 delegates, 23.1%. Ben Carson, 3 delegates, or 9.3%. Rand Paul, 1 delegate, 8,481 votes, 4.1%. Officially, Rand Paul did drop out this morning, stating the lack of funds and support as his main cause. Jeb Bush, 1 delegate at 2.8%. Carly Fiorina, 1 delegate, 1.9%. And John Kasich, 1 delegate at 1.9%. For the Democrats, it was actually decided by a coin toss which gave Hillary 6 wins out of 6 tosses. Hillary Clinton got 23 delegates and Bernie Sanders 21 delegates. This has been your lowdown for February 3rd, 2016.
Okay. Hey, howdy. This is Randy Kelton, Rudolph Radio, on this Friday, the 5th day of February, 2016. And I'm going to start out today. We have the phone lines open. We'll keep them open all night. So if you have a question or comment, give us a call. But while I'm waiting for the phones to start, I'm going to talk about language. I have been for the last 3 or 4 shows. But if we are to take back our legal system, there are some things we have to know and some habits that we need to develop that will increase our effectiveness when we deal with these folks. And most of it goes to language and how human beings react to language. I think last week I talked about how to write legal documents, or how to better write legal documents. And I'm going to start out talking about some of the more subtle things concerning writing well-structured legal documents. The first thing I want to talk about is rapport. In order to get someone to be able to read your document and come away from it with an understanding of what you're trying to import, first thing you have to do is get rapport. You have to give them a reason to read the next word. A lot of these documents start out and somebody has no idea what they're looking for, or what they're reading, or where this person's going. They just start putting words in there. Large number of these legal documents start out with listing the parties and then listing venue. And in my opinion, that's a really bad mistake, because you're already boring the reader from the get-go. The first thing that should be in the document is you should tell them what you're going to tell them. Now, there is a pseudo-structure to legal documents. The judges want parties right at the top and venue right after parties. But you can put something in front of parties, and the thing you should put in front of parties is not necessarily a summary of what you're going to say, but just basically a sentence, maybe two sentences, telling the judge what this document is going to be about. That gives the reader referential index. It gives them a place in their mind to go mark this out. And everything, now you're telling them everything I'm going to talk about from here down, say it's going to be about a quiet title action, where I will be challenging the validity of a document filed in the public record, specifically a deed of trust, an assignment, whatever. Now he knows where you're going to be going with everything. Now he has a context in which to put it. Then you give him the parties, then the venue, you show that he has venue, has jurisdiction in venue, and then you go to statement of facts. The statement of facts, we've talked about this before, and how if it's well done, stating the facts is essentially an art form. And it goes to artful vagueness. You know, I tell these stories on the air, and if you go back and think about the stories that I tell, and consider the detail I give you when I tell the story. When I give detail in a story, I try to only select detail that must be there. Say I'm going to talk about walking down on a beach. I can talk about the feel of the sand against my feet, the temperature of the air, the sea breeze. But I can't talk about a horn honking in the background. Or I can, but it doesn't have to be there. If I only give you information that must be there, then you have to fill in all the blanks. If I don't tell you what the temperature is, you will put in a temperature that would meet your own personal expectation of what the temperature should be on a beach. The smells, all of these other aspects of a beach that don't have to be there, I don't put them in. I read a book by Dean Koontz. And in this story, he was an investigator, and he went to see the widow of an investigator who had investigated some person. But this investigator died, so he went to see if the wife had some of the information, the files that he needed. He spent about 5 pages describing the place where she lived. Aging motorhomes, small aging motorhome, and he described the flower beds and the porch and the colors and the types of paneling inside and the kinds of furniture. Just went on and on and on. If he had have said she lived in an aging but well-kept, aging, quaint, and well-kept mobile home, I would have created in my mind an aging, quaint, but well-kept mobile home that suited my image of what that was. As it was, he started telling me something about it. And this goes to a reality stack. He told about what kind it was, about how long it was. So I have to imagine this type of trailer. It was a Gulfstream. And if anybody knows trailers at all, Gulfstreams are these shiny aluminum ones. So I create this shiny aluminum trailer in my brain. And then he tells me how long it is, and I have to create how long it is. And he tells me how big the porch is, and I have to take my image and adjust it to put this porch on it. And he tells me about flower beds, and I have to just put the flower beds in, and on and on and on and on. And I have to keep adjusting my images to suit this description he's making. If he had have given me just enough information for me to create in my own mind a motorhome that fit my concept, I would have been in much better rapport with him. As it was, I wanted to bounce the book off the wall because he was really annoying me with superfluous and unnecessary detail. When you write a statement of facts, give the facts that must be there and try to give them in a way so that the listener has to construct a scenario himself for the most part. And you just give enough facts to give him direction so the scenario fits the situation. If a fact is not absolutely necessary to the outcome, and the fact would cause the reader to have to adjust their concept of of the facts to your particular situation, don't tell it. Just leave it out. And I'm afraid my computer just got itself a headache. Hold on just a second. I'm trying to keep the whole system from crashing. Anyway, I'll try to keep this thing going until we go to break. Anyway, artful vagueness. When I tell my stories, you listen to the stories, and I only tell, the stories are always real sparse. I don't give any extra detail. So that's so that you create the story essentially yourself. And when you create that story, then it's much more immediate to you. Excuse me, I'm a little distracted here. I'm afraid I may have to shut my whole system down here to get this thing to come back. Don't crash. If you lose me, I'll be back in a second. Okay, got something. I think I can fix it. Got it. Okay, sorry about that little distraction. I had to go into the system and shut off one of these programs from the backside. But I got it. Okay, we do have 2 or 3 calls, and since I've kind of screwed up my momentum, I will go ahead and go to Scott in Texas. Hello, Scott.
How you doing there, Mr. Kelton?
Yeah, I'm not doing so good. My system's trying to crash on me, and I'm trying to keep it not crashing. Okay, what do you have for us today?
Today was a pretty good day. I finally went to Tarrant County and indicted a judge from Addison, Texas, with the Tarrant County Grand Jury for official oppression, 3903 in the Texas Penal Code. Thank you very much. Boom.
Wonderful. This was, we were testing out the district attorney. This is the district attorney that I worked on when she first got in office and got her to stand aside when I brought criminal complaints against the Dallas County district attorney. I brought criminal complaints to the Tarrant County district attorney, accusing the Dallas County district attorney of interfering with my access to a grand jury. So the Tarrant County district attorney decided not to interfere with my access to the grand jury. And I wanted to see if she would do the same thing for someone else. And she did. Now we'll see what kind of response we get back. This should be very interesting because the complaint I filed, I got a letter from the foreman of the grand jury said that the grand jury examined into my accusations and found no Tarrant County complaints subject to indictment. Well, now I'll be filing criminal charges against the foreman. So I want to see what happens this time. It will be interesting. And this was a great complaint because a judge yelled at him in court, a municipal judge. He's going to get this judge's attitude adjusted. Hang on, Randy Kelton, Rule of Law Radio. And while we're on break, have a look at our sponsors and look at our gun giveaway. We've got our fundraiser going. We use all the help we can get. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Scott in Texas. So, Scott, you went down there, and what went on? How did it go? Give us the juicy details.
Well, it was really, really simple, too. You know, I mean, I walked through there, and as soon as I got to the screener thing, I said, "There's a Tarrant County jury on the second floor, grand jury on the second floor." I go, "Yep." And so I was like, okay, went through their little hoops and walked up there, asked the guy, you know, I said, is Tarrant, you know, I'm here to give you this paperwork for the grand jury. And he said, okay. And I asked if I could get the bailiff's name, and he gave me his name. And I asked him for the grand jury form, his name. He said, I'm not going to give you that. And I was like, okay. And so it says the grand jury in. They said, yeah. He said, yeah, they're convened right now. I said, okay, we'll just give them this. I'll give them 13 copies and turned around, walked off, and drove home. So this case is going to get even better because the cop gave me, when he got me booked in jail after he smashed my window out, hauled me to jail, then once he got me to jail is when he figured out my license was invalid. So he charged me with that, but he gave it to Dallas County. Well, I just went this week and got that charge dismissed. And on the dismissal, it says case was filed in Addison, and they didn't have enough prima facie evidence to support a case, and the state respectfully dismissed. So now that he tried trumping up a charge on me while I was in jail, that got kicked out. So now we're talking about the tort letters and stuff. So I'm really interested to figure out how we start going after that.
Well, if he filed a complaint and the complaint was insufficient, and it was insufficient as it's established by the prosecuting attorney, then you file against the officer for filing a fraudulent complaint or securing and executing a document by deception, tampering with a government document, whichever one fits best. Securing and executing probably doesn't fit this one, but tampering certainly would. Or aggravated perjury, where he stated under oath that he had reason to believe and did believe you had committed this crime when in fact he did not have reason to believe, as evidenced by the prosecuting attorney. Now, he's not just some ordinary, everyday, average Joe who can make this mistake. He's a professional police officer. He don't get to make this mistake. So that might be another way to go after it.
Well, whatever, you know, I mean, you were the one that was kind of telling me a little bit about some of the avenues to go, and I'm just kind of like, okay, how do we go teach these people a lesson? I mean, because when he got me to jail, he's like, oh, I found this out. I'm just going to charge you with that too. Like, and you know, another thing, he took my phone and didn't turn that in with the property and went and took it off for about an hour or two, and then came back and turned my phone in. So I think he went and was perusing through my phone to see if he could find any nude pictures or anything, and try to trump up more charges, because I just was remembering about it. There was another guy that was in jail there just for that, having some kind of, you know, pictures on his phone, nudie pictures on his phone and stuff, you know. So I'm like, I bet they were sitting there trying to find other stuff, and then, you know, maybe get a little bogus warrant to try to say, oh yeah, we got this and reason to believe, blah, blah, blah. Just, you know.
Okay, well, didn't you make a video of that?
Well, of the initial stop, yes.
Will you tell everybody what you did with it?
What's the video? If anybody wants to go see it, it's Addison, Texas cops smashing out window. And I thought he just took my phone to go erase the video, but he didn't do it. And I was expecting the video to be completely erased when I got my phone back, but he didn't do it. And it's a good thing because it automatically uploads to the cloud. And I'd have really got him then for tampering with my phone, erasing stuff. But anyhow, like I say, I took the video of the whole encounter and posted it up on YouTube, and it has like 1.8 million hits right now. And so it was crazy. It was amazing.
So now you have him using, what do you use, his nightstick to break your window?
Yeah, a little extendable baton, you know, collapsible baton.
So he used a weapon to break out your window when, according to the district attorney, he lacked probable cause, and he was prominently displaying a deadly weapon. So your allegation that his use of force was excessive is bolstered by the fact that the prosecuting attorney dismissed the complaint for lack of prima facie evidence. Now you got a good shot at first-degree felony aggravated assault. At least you get to make the charge with a little more foundation.
Well, because the original reason or the probable cause was speeding, which he didn't even charge me with to start with.
Well, he couldn't get to probable cause on that anyway.
Exactly.
So he didn't have any. This would be a great place to challenge the application of the transportation code to a traveler.
To jurisdiction.
Go ahead.
It would be challenging the total jurisdiction because he pulled me over for speeding when I'm not speeding according to the code because I'm a traveler. I can't be speeding if I'm not driving a semi or a bus.
This might be what Deborah would call a bank shot, where you go after the officer for first-degree felony aggravated assault because it fits the statute. And I'm sure somebody out there listening is going to say, that's kind of excessive. Well, I didn't write the statute. I just read it. And here's what the legislature said. They said, when we put a pistol on your hip, that is really, really serious business. And you have to be really, really careful. Now, maybe not in other states, but in this state, if anyone commits simple assault and they are prominently displaying a deadly weapon, whether they commit assault with the weapon or not, that's a second-degree felony. Unless they are a public official acting under the color or pretense of an official capacity, then it's a first-degree felony, 20 to life. Our legislators intended that when that policeman put that pistol on his hip, he be very, very careful about how he uses his force. And this might be a very good way of letting them know that we are very serious about it. And you take on his subject matter jurisdiction by saying he never had authority in the first place. You have filed in, I helped Scott put together a challenge subject matter jurisdiction. And in the challenge to subject matter jurisdiction, we went through the transportation code, where the transportation code authorizes police officers to enforce the transportation code. What the code says is that the sheriff of the county can appoint 5 people to enforce the traffic code. And of those 5 people must apply to the Department of Transportation, Department of Public Safety for certification. And then it lists those people who can apply for certification. A peace officer from Addison County does not fall within those parameters. A police officer employed by the city of Addison cannot be certified to enforce the traffic code. It's right there in the code. It's very, very clear. They got a problem. This would be a great bank shot. You're not going after the code directly. You're using it to show he doesn't have jurisdiction. Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
In Japan, where pampering your dog is serious stuff, pet lovers can now keep track of every step their beloved pooches take. I'm Dr. Catherine Albrecht, back to tell you about the latest in pet equipment, dog pedometers, in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
On weekends in Tokyo's Yoyogi Park, it's common to see women wheeling their dogs in strollers, dressed in frilly doggy attire. In case you didn't know, pampering pets in Japan is a national pastime. Now dog lovers have a new way to dote on their pets, a cloud-connected pedometer pendant that tracks each time Fido puts one paw in front of the other. The pedometer is strapped to the dog's neck and logs steps, shivering motions, and body temperature. Transfer this vital data to the cloud, owners, and their cell phones at the pendant. Monitoring pups with pendants? Pardon my Japanese, but I'd say sayonara to this trend. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
You're listening to the Logos Radio Network. at logosradionetwork.com.
Yeah, I got a warrant, and I'm going to serve them to the head government, them, prosecute them. Okay.
Okay, we are back. Randy Kelton, Real Bar Radio, here with Scott from Texas. Okay, Scott, so probably you already have the best complaint we can file, and that's the first-degree felony aggravated assault. But then the grand jury is very unlikely that they would indict this officer for first-degree felony aggravated assault, even though it exactly fits the statute. But what they might do is if you charged him in the alternative with a lesser included offense, if you upset the grand jury at this guy and they don't want to indict him for a first-degree felony, which is extreme to say the least, they just might take him on for something lesser. Official oppression.
It's always back to 3903.
Yeah, it is. That's my catch-all. And Eddie and I were at a House subcommittee meeting, and they were discussing 3903, discussing a bill to upgrade it from a misdemeanor to a felony where there was bodily injury. And a prosecuting attorney from Houston stood up in front of the subcommittee, looked them right in the eye, and lied like a dog. He told them the only thing he could charge the officer with, or these officers, there were 6 of them, that chased a 16-year-old boy, a little 90-pound boy. The kid stopped and laid down on his face with his arms and legs straight out. They ran up to him and kicked and stomped him for 1 minute and 20 seconds. Now, that don't sound like a long time. But if you got 6 men kicking and stomping you, that is a very long time. And the city was absolutely incensed, and a whole number of churches were pushing this legislation. Well, the lawyer got up in front of the subcommittee and told them that the only thing he could charge them with was Class A misdemeanor official oppression. And Eddie got up there and just reamed them good and told the committee, pointed right at that lawyer, this lawyer got up here and he lied like a dog to you. And he quoted him 2202B2A. It was very clear he could be charged with first-degree felony. Every one of them could have. And that probably would have been a really good idea, because the likelihood of them getting indicted for first-degree felony is somewhere between little and none. Most likely they would get no bill. But just the fact that for acting on their adrenaline, kicking and stomping this kid just because they could, it would end that garbage. Because you never know when you're going to get a grand jury that's got somebody on there that may have been through a similar experience, or has had a son or a grandson who's been through a similar experience. Well, a grand jury's like playing Russian roulette. You just never know. So, it'd be interesting to see how this shakes out. And we talked about filing against the judge and against the officer. And he's filed against the judge this week. He's going to wait another week or so before he files against the officer, so that the grand jury doesn't get them both and throw one or both of them out. They have to consider each of them separately. But I suspect that when they get a call, and they most likely will get a call, in this case probably from the Texas Rangers, because now the district attorney no longer has a public integrity unit. That duty's been turned over to the Texas Rangers. So when this judge gets a call from the Texas Rangers wanting to know why they shouldn't get him indicted for official oppression, that ought to get real interesting. I'd like to be a fly on the wall when the judge gets the call. I just found out about Judge Cooper in Garland. In August of last year, I went to, was it year before last? I went to stop a foreclosure. And I was helping a woman with her foreclosure issue. And Judge Cooper, he was a lawyer, so he knew better. Real arrogant little snot. they came to foreclose, and they had a trustee's deed, but it hadn't been filed with the county clerk. So I challenged subject matter jurisdiction of the court, and the judge said, "Well, Mr. Kelton, they have first I challenged subject matter jurisdiction," and he said, "Well, Mr. Kelton, he started the hearing and I said, objection, Your Honor, I'm here at arm's length to the court. I have a challenge subject matter jurisdiction for the court." And he said, "Yes, Mr. Kelton, you just filed that 20 minutes ago." "Yes, Your Honor, as a matter of fact, I did." "Well, I'm going to deny that." "So you're going to deny that challenge to subject matter jurisdiction without reading it?" "I told you my decision, Mr. Kelton." "Okay." So we went on, and they got to the trustee's deed, and I said, "That trustee's deed not filed in the public record." "Well, Mr. Kelton, he has it." "Yes, he does, but you can't see it." Well, he ruled this guy's favor anyway. Through this 80-year-old woman out on the street. She'd been in that house for 30 or something years. They were outside the statute of limitations, all kinds of problems with this. So I went to the district attorney and went straight to the Dallas County district attorney and filed criminal charges with him. And that's the ones that then they threw us out of the building. And then I actually filed criminal charges against the district attorney in Dallas County for not taking the criminal charges against this judge. And I did that in October of last year. And in October of last year, Judge Cooper retired. Very interesting. Now, I don't know if him facing criminal charges because of me is the reason he retired. But I certainly like to think it is. And I know that after that, when we had people file challenges to subject matter jurisdiction, the judges read them. They stopped dismissing them without reading them. So this stuff does have an effect. It does get their attention. And Scott, when do you have your next hearing before this judge?
It's going to come up in May. I think it's like 4 months out. 3 months, a good 3 months out. So it seems like forever. So I've got a long time.
Have you filed a motion for speedy trial?
No, not yet.
Are you considering it?
Not really. Not for a little bit. I want to get all the evidence. I want to get the video and stuff that all the cops have.
Well, in order to preserve your right to a speedy trial, you have to request it.
Oh.
So you might be everybody, when they get any kind of charge, would be to file a motion for speedy trial immediately. This is an issue with traffic that needs to be adjudicated. The legislature, in considering, I forget the number of it. I used to have it in my head, the Speedy Trial Act. The legislature passed it, twice, and the courts overturned it twice for the same reason. So I think the legislature did that on purpose. What they said was that if a Class C misdemeanor was not tried in 30 days, the judge was required to enter a ruling of dismissal. And the court said the legislature had no power to direct a judge's ruling and rule the Speedy Trial Act unconstitutional on that basis. But the statute also defined what was considered speedy. 30 days on a Class C misdemeanor is what the legislature defined as speedy, and that should stand as probable cause to believe that the trial is not speedy if they exceed 30 days, and they should have to show cause. That's something we need tested. Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. We are really stacking up on the call, so we'll finish up with Scott on the other side. While we're on break, go check out our sponsors and help us with this.
Easy.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Scott in Texas. So, Scott, what are you going to file against the officer?
I'm going to go 3903 official oppression. It fits the bill way better. It stands a better shot. It's not just going after the cop and trying to throw him in prison, but it's definitely going to give him a slap of reality. It's like, you can't be doing this to people, and wake up and, do your job correctly. And I'm not, it's not like I'm against the cops. I'm against the system that's training them to do this. So they need to realize if they're going to just be blind order takers and be like little Nazi Hitlers. They're going to get slapped with the law, and they're going to get shown the other side of it. And I feel like I've got them on the ropes now. It's really a good feeling. I encourage everybody to, just do everything you can to get the material, get Eddie's material, listen to the shows, spread the word. More people, once they start realizing what is the truth and what is the law, you're going to get empowered and you're going to stand up and do the right thing. So I just encourage everybody to keep the fight up and don't back down.
Yeah.
And I'll talk to you later on this week, because I've got the complaint already wrote up against the cop. And now that I've learned how to write these things, once y'all all listen and learn how to start putting these things together and listening to Randy on, using the verbiage, using the wording correctly, take your emotions out, just stick to the facts, be able to cite the law, put everything in proper perspective, or not perspective, but proper margins and all that stuff. You know how to write it all out. And man, when you write that stuff out, you're really proud of what you've done because you put it down, you made it look good, made it look right, and you did a great job. I mean, and I'm learning a lot, and I encourage everybody to do that. And I know there's a lot of calls, so I will get off the phone and let you help everybody else. And thank y'all, and have a great evening. Okay,
thank you, Scott. Okay, now we're going to go to Spencer in Washington. Hello, Spencer. What do you have for us today?
How's it going, Randy? Got a couple things. I wanted to comment on adding details, when to add them, what details are appropriate. And I want to add a little bit of humor to your show here tonight as well, because this brings me back to a moment a few weeks ago. I was woken up abruptly in the middle of a dream. It was a great dream, really, really great dream. And turned to the woman, and, I was a little bit flustered. Hey, you woke me up out of this amazing dream. And, it's like, oh, what was it about? I was like, well, it was me and a bunch of women on a beach. Instantly I was doing this on purpose. It's fun to get people flustered, get them worked up, and then bring them back down again. I take joy in doing that. But, I got her flustered a bit because instantly you assume there's what's the way to say it? Interesting things happening. I'm trying to keep this clean for the radio here. That's instantly the thing you assume. And when you're not putting all the details in a legal document, people are making those same assumptions. And at this point, I didn't even remember what the dream was, but I was just going to go for it just for the story here. And she started to get a little bit flustered. So I was like, well, I was commanding them all to make me pancakes. And kind of de-escalated a little bit just to add a little bit more to the story, because that's not what you'd expect at all. So if you leave out some of these details, people may make the wrong assumption. You want to go with what's normal in that scenario, and if you're outside of what's normal for that scenario, you might want to add a few extra details. And just to throw it completely off the wall, it still seemed a little bit absurd of a dream. So I was like, you know what? We were on the beach in Antarctica making these pancakes, feeding them to camels, and it sends them completely off the wall. And that's not the assumption they were making. It takes them completely out of the environment they were expecting to be in and puts them in your environment.
Okay, this is what you're talking about is pretty complex. And it's one of the things that I'm trying to get to in some of these presentations I'm doing. You did a pace, you did a lead, then you did a pattern interruption. If I want to stick something in somebody's mind, if I want to push something past their ability to consciously analyze it, I'll use a tool like that. I have a presentation I do on the rubber ball theory, and I tell people that there is no such thing as good and evil. Yeah, I know that you move around in the world, it sure seems that way, but there is no such thing as good and evil. Well, that may not be true. But you'll find if you treat it as if it is true, it works very well. Now, what I've done is set up a logical sequence. I'm going to come back later, and I'm going to make a statement that'll cause people to feel incredulous. Give me a break. And then I'm going to give them a logical conclusion, and then I'm going to do a pattern interruption. Pattern interruptions cause amnesia for what you just did. If you want to tell somebody something and you don't want them to consciously analyze it, follow it with a pattern interruption. you set your lady friend up to think that women are after you, and then you did a pattern interruption and used a confusion technique to get her trying to make sense of what you're talking about and cause her to lose the conscious ability to consciously store what you had just told her. So that kind of thing tends to pass the conscious awareness and stick around in the inner mind. So she starts getting jealous of you and starts worrying about everywhere you go. You did that. But I do want to spend some time. I'm going to try to spend some time at the beginning of the shows talking about some of these tools. If you've listened to the show or not a while, you know that I've studied psychology and neurolinguistic programming for a long time. And once you know and understand these tools, you use them without even thinking about them, because they're not things that you do and then go have breakfast. It's just a normal part of communication. But I do want you to begin to understand the patterns. Once you know what these patterns are, you're able to recognize them. And I'm going through all of these techniques to find the ones that seem to be what is used against other people the most, and give you a label to put on that, like a complex equivalent. If you're in court and the prosecutor uses a term that's a normal sounding term, but you're certain that has another meaning in law, like driver, objection. The prosecutor has used a complex equivalent to create a distortion in that he's used a term that is a nominalization without giving us the right term is the deep content so that we can fully understand what he says. I have a meaning for driver. He has a meaning for driver. But I'm certain that our meanings are not the same. Will you have him explain exactly what he means by driver? And the judge will be standing there scratching his head, wondering what you were just talking about. And if he tells you he doesn't know what you were talking about, court's problem, not my problem. I'm not responsible for your ignorance. But I will be trying to develop names for these patterns to look for. I mean, Spencer, I'm sure you're familiar with red herrings and straw man issues. There's a whole lot more out there. Most people are familiar with argumentum ad hominem, but argumentum ad bacillum, there's a whole list of them. I'm going to start listing those out and explaining them. And when we explain them, if we attach a name to them, then you'll begin to hear this pattern and you'll say, wait a minute, I know what that is. And you stick the name on it. Now you catch them. And we'll be able to catch them using these patterns and trip them up on a level that's mostly outside their awareness. Does that make any sense, Chris? Not Chris, Spencer.
Yeah. I'm following you.
Yeah, and I'm struggling with finding a way to present this so it makes sense. So sometimes I'm a little confusing. I apologize. I'm trying to find a way to present it different than the way I learned it. So I'm trying to put it in the context of you and I dealing with public officials. In effect, I'm trying to build us the tool chest. When you go into court, you've got a lawyer and a judge, and they've got this huge tool chest. They've got all these things they can do because they do this all day, every day. They got lots of stuff they can do. You hardly ever do this. So you don't have a lot of options in your tool chest. Well, I'm trying to build some new tools that we can put in there. And it won't take many, even though they've got a lot, because very few people come in there and trip them up good and hard. And it's been my experience that when you trip up a lawyer, they get all flustered. And they do worse than ordinary people do. Everybody says never put a lawyer on the stand. They make horrible witnesses. They're good from the other side, but when you turn it back on them, they stink. Okay, hang on. About to go to break. Louisville Law Radio, call in number 512-646-1984. We'll be right back.
It's all according to the will of the Almighty. I read his book and it says he cares not for unsightly. These warmongers come by that term rightly.
Okay, we are back. Randy Kelton, Blue Radio, and we're talking to Spencer in Washington. Okay, Spencer, I'll shut up now. I kind of jumped in there in the middle. Oh, we do have one question. Have you ever studied neuro-linguistic programming?
I've never even heard of it.
Okay, well, what you did was a pattern. And one of the things that once I looked at it, I studied psychology for a long time. I was studying psychology before neuro-linguistic programming came around, but when it came along, they were the first ones that treated the living mind as if it was ultimately understandable. And most of the patterns that they demonstrate are patterns that people use all the time. And all these guys did was just kind of isolated these patterns out from the plethora of possibilities. So you already understand some of the structures. Once you can name them and list out the elements of them, then you can use them much more consistently. And that's the kind of thing I'm trying to present in this show. Okay, back to you. Did you have another comment?
I did, and this one's really, really quick. On, I think it was the 8th of last month, there's a case that I'm working on here in the state of Washington. I sent in an interrogatory. I haven't heard back. About a week and a half ago, I called them up just to confirm that they had received it. They said,
okay. Wait, hold on. Let me get a little clarification. Interrogatory, you're saying interrogatory specific, and you're not just saying discovery in general.
I filed discovery, and the only thing they provided to me was a citation and officer's affidavit, because that's all they were admitting into court. So then I received that, and then I went a little bit further because there's a little bit more information that I wanted.
Oh, wait, hold on. You're in Washington. Is this a traffic issue?
Yes.
Oh, that's interesting, because in Texas, on a Class A misdemeanor, they won't allow discovery. So that's interesting. That's great. You can get discovery on a Class C misdemeanor. Go ahead.
This is a civil case, to my understanding. It's a civil case.
Yeah, that was another interesting thing about Washington, that in Washington your traffic is civil and not criminal. Most other states they consider it criminal, but not all. So that was also interesting to hear. It kind of changes the strategy how you can go about it. Can you cross complain in the civil in Washington?
That I don't know.
That's, in where it's criminal, you can't cross complain in criminal, because criminal is a subset of civil, and criminal only does criminal. So if you have a cross complaint, then you would have to file a separate case. But if in Washington, if it's civil already, you should be able to file a cross complaint or counter complaint. That would be fun. Okay, go ahead. I interrupted you again.
They haven't responded, and their 30-day period is up on, actually, it's either Monday or Tuesday. I have a strong feeling I'm not going to get a response here. So what I'm going to have to do is a motion to compel. I've only heard of it. I've never seen what one is like, or what the process is for filing that. I know you don't know Washington's laws, but
that should be really easy to find. Just do a search. If you're in Washington, you'll get hits from Washington. And just do a search on motion to compel discovery, because everybody files them. Okay. Discovery is voluntary, but nobody volunteers. So you always have to file a motion to compel. You'll probably find 1,000 of them. Just do a search online. You pull down the motion to compel and leave all the case law in there, and just take out their specifics and drop yours in.
Okay, that shouldn't be too hard.
Yeah, I don't use Lexis or Westlaw anymore. They're a waste of time. I do a lot better on the internet. I just put in my term and I get great stuff. If I was looking for motion to compel, You do a search and you start reading these articles. You got a lot of lawyers out there that want to get business from other lawyers. 50% of a lawyer's business generally comes from referrals. Lawyer gets a client, and the client has an issue this lawyer doesn't handle. He wants another lawyer he can refer him to. So they write articles, scholarly legal articles, about what they are especially good at, because they want other lawyers calling them to handle their issues. So you can find really good articles, and they'll post their briefs and pleadings. If you go to Lexis and you try to get briefs and pleadings, it'll cost you about $3,000 a month. But heck, you can go on the internet and get them all a day. And 90% of my pleadings or motions I write, I'm cutting and pasting and just stitching the pieces, changing tenses and stuff so that the language stitches together. Why should I write it when somebody else has done a better job than I can do?
I was thinking it's probably really, really simple. Just, probably less than a paragraph, a couple sentences, and then attaching the interrogatory that I sent in would suffice. But
yeah, it's kind of like when we file a action in foreclosure, they move it to the federal court and they file a 12B6. They just go pull the 12B6 out of their file, change a couple of details on it, boom. I've got hundreds of them. They're almost all identical. Exact same structure, exact same case law. They're all using the same one. So most of law is this way. And this is one of the things I suggest to people. Don't ever write a motion from scratch if you can avoid it. Unless it's some strange motion like a Mary Carter agreement motion. I mean, that's kind of weird. You almost never see it. You may have trouble finding one. But all the standard stuff, just go on the internet, run a search for whatever your issue is, and you get all kind of hits on it. You'll get briefs, pleadings, treatises. And in the treatises are great because you find the section that goes to what you're talking about, and you just capture it out and drop it right in. And when the judge reads it, he will look at it. And he got this from a pro se. And he reads that, and he knows the pro se did not write that. He knows this guy took that out of a brief or a pleading somewhere. And that will give the judge reason to give it more credence. And if you always get motions that have been filed of a similar nature, all of these lawyers try to use whatever the most common litigation guide is. Primary reason is they want their motion to look exactly like every other motion that judge has gotten. All the venue, jurisdiction, and the standard case law say it's an eviction. This lawyer wants to use exactly the same case law that the lawyer in front of him used, because he don't want the judge to have to mess with it. If the judge has seen that case law 100 times, he don't have to read it, he don't have to question it, he just move right on past it. But if a pro se comes in and does it all from scratch, the judge is going to have 20 cases in there he's never seen. And you really think that judge is going to pull out those cases and read them? Denied. So the best advice for writing pleadings is you do three things. Plagiarize, plagiarize, plagiarize. In that order. Yeah. Anyway, okay, enough of that.
That's all I've got for tonight.
Okay, thank you, Spencer. Okay, now we're going to go to Chris in Pennsylvania. Hello, Chris.
Hello, Randy. How are you?
I am good. How is your issue going?
Well, I don't think it's going very well. We had a summary judgment that the bank put in stating that we didn't have enough evidence to make this case, and I believe our attorney yesterday found out.
Okay, wait, hold on. You back up and give everybody a brief synopsis. This is Chris from Pennsylvania that filed a bankruptcy and claimed the property is unsecured in bankruptcy and got the claim, what do they call it? Not dismissed. Go ahead, help me out, Chris. What do they call it when they write it off?
Discharged.
Discharged. Okay.
Yeah,
so
discharged.
Okay, so he claimed the property is unsecured. The other side couldn't prove up that it was secured, so the bankruptcy discharged the debt. Now they're coming back trying to foreclose on the deed of trust. Is that correct?
Correct.
Okay.
Yeah,
now, what's going on right now?
Well, the bank put in a summary judgment while we were in discovery, stating that we didn't have enough evidence to say to the judge that, there's
okay.
evidence.
What's the nature of the action before the court at the moment?
The nature is just a summary judgment.
No. Summary judgment for what? What's the case they're trying to get a summary judgment on?
On our actual case, on the foreclosure.
No. Wait a minute. Okay, there we go. I'm squeezing this out of you. Okay, that's the bank is trying to. It has filed in the court to foreclose, and they're asking for summary judgment. Okay, now we're up to speed.
They're asking to foreclose based on an assignment they took while we were in bankruptcy from a bank that had been closed for 5 years using MERS as their nominee.
Hang on. Have I got a good shot for you when we come back? Randy Kelton, Root of Law Radio. Our call-in number, 512-646-1984. Remember, we have our fundraiser going, and right now we're really kind of struggling. We're not getting near as much in as we're going to need to keep the radio station going, so help us out if you can. We'll be right back.
Now.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me.
Okay, we are back. Randy Kelton, Root of Law Radio, and we're talking to Chris in Pennsylvania. Okay, you got the debt discharge, so there is no debt. Now you have a lender suing to foreclose based on an assignment from a non-existent company. Judge Schreck in New York called these vampire lenders. I would suggest that you consider filing a quiet title action against the assignment and challenge the validity of the assignment. If you can get a ruling on that, you can bring that back to this court as res judicata. And you could probably move this court for an abatement pending a state determination on the validity of the assignment.
Okay. That's the only thing that the bank is bringing to court is the fact that they have this assignment, and that's kind of what the judge is making his ruling on.
Wait, say that again.
Well, we were waiting for the summary judgment to come through. We've been waiting about 3 months now. The bank filed it, and we appealed, and we showed why we believe we should continue with our discovery. And just 2 days ago, our attorney let us know that the judge has sided for the bank in the summary judgment.
Well, that's kind of always. I mean, here we have a bank that's foreclosing on a mortgage, a security instrument after the debt when there is no existing debt, and the bankruptcy law forbids them to foreclose. Are you in a federal court?
No, we're not. We're in civil court.
No, civil. I mean, Pennsylvania State Court.
I mean, Pennsylvania State Court. Yeah. So.
Yeah. How do they get past the prohibition against attempting to enforce the mortgage instrument after the debt has been discharged?
But we're not sure. We have a meeting with our attorney Sunday, so we're going to go over and talk to her about. She just texted me that not to panic and that there are issues we need to discuss. So my question was, with what's been happening with Wells Fargo, their lawsuit that just went through, I believe.
I am not familiar with that.
Well, I saw on a mortgage news that they were finally sued through the state of New York for the False Claims Act for $1.2 billion.
Ooh. Was the suit just filed, or has it been adjudicated?
It's been adjudicated, and no one's making any statements at this point. But they filed. The state has been trying to get them for creating loans through FHA that they knew would default, and then taking the insurance money from the federal government. So they used the False Claims Act to make their case, and they won, I guess. From what I've been reading, the bank has been totaled with a $1.2 billion reciprocity for that.
Okay, was this a court determination or an appeals determination? Is it citable?
I think it is citable. I think
citable is collateral estoppel. Now you can go back, and you should be able to charge if your loan falls within the parameters of what the claim is against Wells Fargo. You should be able to claim fraud, and that become collateral estoppel.
Right. Okay. Now, here's my question. Since Wells Fargo purchased Wachovia, who was the originator of the loan, how does that make play for Wells Fargo, who took over the assignment after Wachovia supposedly closed?
I don't think that would back up that far. If they've accused Wells Fargo of wrongdoing, that wouldn't go to Wachovia because Wachovia was a separate entity. So anything Wachovia did before Wells Fargo took them over would be on Wachovia and not Wells Fargo. I don't think you could go there.
Okay, well, that was my question, because it seemed as though what the issue was the fact that they were taking these loans on in order to collect the insurance money, and if that's exactly what they've done with us by taking this loan on during a bankruptcy, knowing that my wife had taken out a no-doc loan, which they told her she couldn't afford the loan to begin with, but they made all kinds of underwriting changes to make it appear as though she could.
So the whole loan was fraudulent on its face.
Right.
Did you make that claim?
Well, we didn't make that claim specifically. No. We didn't get back that far. We were merely making claims on the assignment, since the assignment was so fraudulently put together.
Okay, so you're in... Oh, okay. So your defense... You're defending a foreclosure, and you're defending only on the assignment. Okay, so you still have opportunity to go back after them, even if they do get a foreclosure. So you won't wind up with collateral estoppel yourself or res judicata. So you've got claims you can make. This is odd because the code in the bankruptcy code, I think it's 11 U.S.C. 256, is very specific in that it forbids the lender from attempting to collect once state debt has been discharged. So really odd how they got here. Have you seen the summary judgment order?
I have not yet.
I take it you did make this challenge directly.
Correct.
So it'll be interesting to see how the court tries to rule around the federal prohibition. Because in reading the code, it was very clear. They're absolutely forbidden from trying to collect on a debt once the debt has been discharged. And here that's exactly what they're doing.
Right. We're wondering how they got around the fact that both Fannie Mae, who apparently securitized this loan upon its inception, was noted in the credit report stating that the account was closed due to a Chapter 7 bankruptcy, along with Wells Fargo. So which one of them was actually the lender in this case that could make that claim on the credit report?
Are both of them in your credit?
Both of them were named creditors. Both of them made a claim on the credit report. Fannie Mae isn't listed anywhere in our loan. Fannie Mae has no, mention in anything from the origination to date.
Well, have you considered suing Fannie Mae? Okay, let me back up a step. Did you make a counterclaim against Wells Fargo?
Fannie Mae? No counterclaim.
No, in the foreclosures issue. You didn't make a counterclaim?
No.
Ooh, bummer. Hang on. Randy Kelton, Roosevelt Radio. Our call-in number, 512-646-1984. Marcus E. there. We'll get to you. We'll be right back.
Burglars are breaking into hotel rooms by effortlessly and silently opening those key card locks. I'm Dr. Catherine Albrecht, and I'll be back to tell you how the hackers do it and what it means for you, the traveler, in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
When Janet Wolf returned to her room at the Hyatt in Houston and found her laptop stolen, there was no sign of forced entry, and the housekeeper was ruled out as a suspect. So who done it? A hacker, it turns out, using a digital tool that spoofs the computerized keycard locks in place at 4 million hotel rooms. After break-ins across Texas, the lock company Onity offered a pretty lame solution, plugging the locks with putty. The real solution requires replacing every lock circuit board, something Onity wants the hotels to pay for. But what if they don't? Well, it may be time to stay somewhere else. Motel 6, anyone? I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Actually be kidding about chemtrails.
Looking for some truth? You found it. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Roosevelt Radio, and we're talking to Chris in Pennsylvania. Okay, Chris, so you're waiting for the order on the summary judgment.
Correct.
So
we haven't seen it yet. Our lawyer has just always informed us about it, so we're going to meet with her, and we're just waiting to see what our options are from this point. How they got over the bankruptcy is a mind-boggler.
Okay, you've got a lot of options. Just because they granted summary judgment, that doesn't mean there's a whole lot you can do. One of the things you might do is look at a quiet title action. I would have hoped that would have been the first thing right after the bankruptcy is you file a quiet title against the deed of trust and maintain that since there is no underlying debt, then there is nothing for the bank to collect on the deed of trust. It's unenforceable.
Right. That was our intent. I mean, that's where we were trying to go with this before they put in the summary judgment. So that's inevitably where we're going to end up putting in a quiet title, because if there's no debt,
yeah. Well, this is the assumption. It'll almost certainly go to an appeal, and that's going to take another 6-8 months. And we have a lot of things are happening now. So before it gets there may be enough happening to make sure this gets cut off. But I'm really concerned that the bank can still come back after you after they've been ordered by the bankruptcy court or by the legislature to stop. I will be very interested to see how they get around that.
Right. I was surprised that the bank actually was able to put in a stay to continue to foreclose when they couldn't support a claim to have owned the mortgage. They hadn't filed an assignment of mortgage at that point.
Have you challenged the subject matter jurisdiction of the court?
No.
How did this bank establish legal capacity to invoke the subject matter jurisdiction of the court?
That's a good question.
If they don't have a valid claim, if they had a valid claim, they would have brought it at the bankruptcy hearing. The bankruptcy hearing the court apparently ruled that they didn't have a valid claim, so that should be collateral estoppel. And the thing about challenge subject matter jurisdiction, it's a challenge you can make at any time, no matter how remote in history. So you can go back and challenge this, claim that this plaintiff has no power to invoke the competence of the court. And the way they explained it in Michigan was a nice way of putting it. The court has subject matter jurisdiction over the particular type of case, and it has venue because of the location of the property. But the plaintiff is unable to invoke that subject matter jurisdiction, so the court can never gain competency to hear the case, not because they're not the right court in the right place, but that the plaintiff is unable to invoke that competency.
Right.
That should get one right away. Well, actually, I'd want to see what the judge writes in the summary judgment. But as soon as I saw it, if the judge is not addressing all of the issues, then that's another thing that I've always had a problem with. When you have issues before the court and the judge reads one of them and ignores the others, that should get a criminal complaint against the judge for denial of due process. And they do this stuff all the time.
Right. I heard your last, the first gentleman you were speaking with about that.
See, yeah, that's a common thing. You put in a bunch of claims and they pick the one they like, dismiss the one they like, and then just dismiss the case based on that and ignore all the rest of the claims. So I'm wanting to go after the judges, unless the judge is right. I had someone in Austin who, someone I used to work with, just got a paralegal degree, and he went to work for a law firm as a apprentice. So he's working for him for free for 14 months. And this is one of these legal aid law firms who had filed suit, and the court ruled against him, and they filed an appeal. And I looked at their suit, and on the surface, it looked like the bank was the Court of Appeals was screwing them around. But when I looked closer, they were right. They'd made the wrong arguments. They argued an assignment, but they claimed that the assignment was a forgery. This Bly character that was all over the internet for being a robo-signer, he's the one that signed it. And they claimed it was a forgery. And I looked at it and I said, well, here's the problem. You're not a party to that document. So you can't claim it's a forgery and that the document is void because it's a forgery. You can't claim it in this context. In this context, it's voidable because we have one entity assigning the property to another entity. The contracts between those two, one of those two would have to make this claim. If the first one who got defrauded by the forgery doesn't have a problem with it, then if they wanted to assign it, and they don't care if they screwed up signing it and didn't get it signed right, they don't care. So if they don't raise an issue, they're the only one that can be harmed. The real issue to have raised is the documents filed in the public record, and the only way it can get authority is to be filed in the public record. Well, Texas state law says that a forged document filed in the public record is void as a matter of law. It's not voidable. It is void as a matter of law and has nothing to do with the parties. The one judge dissented in the three-judge panel on the Court of Appeals in the Fifth Circuit, and that was exactly the issue he brought. That document was void, but they didn't argue it. They didn't bring that to the court. And there were a couple other issues that they didn't bring. So I'd really like to see how the judge ruled, because there's a good chance that you can get this thing overturned. Summary judgments, they don't hold up very well at all. Like 70% of them are, I'm sorry, I'm thinking of default judgments. But in my experience with almost every case that we filed on foreclosure, the other side filed summary judgment, and the judge just granted them. No matter what, they grant them.
Mm-hmm.
That part's frustrating. But it's still just a step in the case. There's a long way to go yet. So next week, call it. If you get that thing, send it to me. I'd like to see the ruling by the court.
I will. I'll email it to you as soon as I get it, so you can take a look.
Yes, I want to see how the judge got to this point, how he got to around the prohibition under the bankruptcy laws.
Right. Our attorney had even brought up before the summary judgment and the appeal to the summary judgment that none of the dates on the inception of this loan matched up, and the judge raised that issue and said, "Yeah, that's an issue I need to look at." So
okay, hang on. About to go to break. Randy Kelton, Rule of Law Radio. Our call-in number 512-646-1984. We'll be right back.
Easy.
Well, karma's lurking around the corner. You better watch every step you take. The good and good will follow you. Yeah, Billy Jerry. Sing reality.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Chris in Pennsylvania. Okay, go ahead, Chris.
No, I was just stating that, in our appeal, that she mentioned a couple of facts about the dates that didn't corroborate with the signing of the mortgage, who it was signed by, when it was signed. Nothing appeared to flow as it should have, and the dates of the mortgage, the payment, the settlement date, they were all different times, different days. None of them matched what they should have been. And she brought that up to the judge, and the judge said that was enough, that I guess it took him 3 months to look at this and come up with his ruling.
How does Pennsylvania law address the particulars of a document filed in the public record?
Here, there's not much, there's not much you can go by. I mean, even though the Recorder of Deeds doesn't have any say in anything, we've just now gone to an e-filing here in the state of Pennsylvania, where there's a way to look all this stuff up online, and just gone online, so now you have access to all of that. And the Recorder of Deeds, we've gotten hooked up to his site, and he sends out these little bulletin emails every once in a while to update you on what's going on in the Recorder of Deeds office. But
the reason I was asking that is if the document purports to transfer a mortgage from one party to another, and the document doesn't accurately describe the mortgage, then that should be enough to get that document ruled invalid, unless the variances are not material. Does it have the right parties? Does it have the right loan number, loan amount?
Yeah.
Other issues that may be at variance, if they're not material, it may not matter.
Right. We were still hoping to get an affidavit from the insurance company to use the homeowner's insurance part that we still had in question, and I was hoping that a quiet title would raise that issue with World Savings and IndyMac being on our homeowner's insurance as being mortgagee, and the fact that IndyMac was indicted for having mortgages on its books that had no assignments with changed loan numbers. And on our homeowner's policy, it distinctly shows IndyMac holding our mortgage for a year and changing the loan number. So I'm not sure if that has any impact on what happened to our mortgage, or how our mortgage went through that scenario and came out sunny side up in Wachovio's lap again.
That's why I'm kind of concerned with no counterclaim, because there should have been a counterclaim claiming that the lender breached the security instrument. and therefore repudiated the security instrument and can't come back now and claim the privilege contained in the security instrument, that they didn't abide by all of the notice requirements.
Right.
So you still may have a way to make that claim. But I have to say, I can't say much more until I've seen the summary judgment, see what the ruling says.
Right. Yeah, we're hoping she has some of this figured out as well, because some of the claims we've made in our appeals and in our opening statements that just we can't see how any of that was overlooked, especially the bankruptcy and the fact that the bank was closed at the time.
The bank didn't exist.
Right. It didn't exist. So therefore, MERS couldn't have been acting as its nominee.
At the very least, that violates the notice requirement of the security instrument.
Right.
The bank, both parties agreed to provide the other parties with all required notices, and the applicable law and severability paragraph where both parties agree to abide by all law. And
right.
The Real Estate Settlement Procedures Act requires these notices. And if they didn't happen, then they breached the contract. And they're foreclosing on the contract, claiming you breached the covenant. Well, you claim they breached the covenant before you could have, so they can't claim the privilege. Yeah, this should have got a good attack on the deed of trust. Okay. Next week we should have it. Call us back next week and we'll talk about it. Should be interesting.
Sounds good.
Thank you, Chris.
Sounds good. Thank you, Randy.
Okay, now we're going to go to Mark in Texas. Hello, Mark.
Hi, Randy. Good evening. Been a long time since I talked to you. It's nice to hear your voice. I've got something that's right along these lines, actually. So I wanted to ask you a question. I've basically taken 2 months off from all this junk, and tonight, as I got home, I noticed that I have 2 things in the mail that's kind of interesting. Just to kind of remind you of where my situation is I have in 2013 an assignment that was signed by an employee of SPS, and this assignment is made by an original lender, which was out of business in 2008, according to the Bressler case and maybe some other evidence, and it's made in the state of Arkansas where MERS has no capacity to make an assignment according to a Supreme Court ruling in Southwest Homes v. MERS. So the assignment itself is absolutely void. I brought that up, but didn't get into that enough. They then subsequently filed something past statute of limitations. I ended up losing in a hearing back in June of 2014 after I had already won, and here we were. So I'm curious about this. This is the thing I wanted to ask you about first. Right now I'm looking into actually filing my FDCPA action against SPS for this false and misleading document, giving them, part of that, but just basically relative to letters they sent me. And here's something of interest. Sorry, it's taking me a while to get to this. Today, I got a IRS Form 1099-C and a Form 1099-A, and one is for cancellation of debt, one is for acquisition or abandonment of secured property. Now, the party that sued me and that won was U.S. Bank as a trustee for J.P. Morgan Chase. They were the party that was assigned this mortgage by this document. The real party probably that brought this suit is probably SPS. And on both this 1099-A and C, it says creditor's name and it says lender's name and it says Select Portfolio Servicing Inc. I do believe that is possibly an FDCPA violation in and of itself. And I wanted to know what you think about that. They're calling themselves the lender, themselves the creditor, when in fact they can't possibly be that. They were, for all practical purposes and based on a letter that I got, just the loan servicer. And so here it is.
If they're the loan servicer, they're acting on behalf of the lender. I think that will go to a matter of wording. What they called themselves will not be, what's the term? It really won't matter. They are what they are, whatever they call themselves. And so the court's going to look at it and say the fact that they put that they are the lender, and instead of putting that they are the agent of the lender, is going to be irrelevant.
Okay.
I mean, it's a distinction, but you'd have to show how you were harmed by that or how you were defrauded by that, and I can't see where you can get there.
Well, there's nothing there. This is just somewhat alarming because I get it. And I knew something like this might be coming, but more or less they're saying they discharged like $30-something thousand bucks, and then as far as that goes, I assume I'm supposed to be liable for tax on that or something to that effect.
What they will be saying is that they discharged it. You didn't have to pay it, so you gained that much. But that's not something I've worked with a lot. Logically, when I consider it, you lost the property. So you get to claim you should be able to claim the entire property as a loss.
Sure.
And then when they send you this 1099, that should be countered by the loss of the property, so it shouldn't cost you anything tax-wise.
Okay.
I wouldn't think, but I'm not the tax guy. Hang on, Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. Charles, I see you there. We will get to you. We've only got 2 hours left. It generally picks up toward the end, so if you got a question or comment, give us a call. We'll be right back.